Poof. I'm here. We're going live. How's it going, everybody? How's your Saturday? It is Saturday, right? How's your Saturday going? I wanted to make a live video today about something that we all feel privileged to do. I mean, that it's common knowledge that this is a privilege we're going to be talking about, And so the thing is, though, if someone is privileged, that means they've traded their rights for that privilege. We don't want to be privileged because that means we've given up our rights. So a passenger has to do with commerce. If someone's a passenger, they're paying for a ride. You understand? So if someone's driving around passengers, they need to have, certifications and stuff. Hey, Toby. Hey, Vince. Little Florida. The thing is if you're privileged to drive, you don't have the right. You've relinquished your right to travel. And there's a question of, different capacities. So even if you are a licensed driver, if you're not transporting cargo or passengers for hire to make profit off the road, then you're not operating in that capacity. So today I wanted to discuss a few things with you about driving. We've already covered the question, do you drive? Are you a driver? Is your car a motor vehicle? Have you bailed your property to the DMV? How do you know the answers to these questions? Hey, thanks, NPC. I might keep the silver thing going to next week. Yeah, Eddie Craig, he's cool and all. But if you go to court and start trying to argue case law for right to travel, these courts are corrupted. So I don't know if that's the best way to do it. I like to use Supreme Court opinions to help people understand what the truth is. But I don't see myself using those in court. That's just me. If I have a court date coming up, I'm going to negotiate with the prosecutor, and I'm going to get him into some kind of agreement where he can't proceed, without screwing up. So, and I am working on starting a new service for people that need administrative assistance, like with the administrative process and stuff. That's coming up real soon. People have needed this for a long time, a way to help people with their charges and stuff. So with that being said, I'm going to jump right in. The Vehicle Code of 1935 says, the question I use when I first get stopped and they ask for license, registration, and insurance, I say, are you planning on using any of those against me in court? Because I'm not into self-incrimination, Hey, Artie. Okay, so if I'm not driving cattle right now, am I still a driver? Because, Artie, you seem to lump everything into one category. If someone's driving cattle, they're driving, right? But if I'm behind the wheel of a car, that makes me a driver too, no matter what capacity I'm operating in. I think you'll be able to use this episode the most, Artie. So let's get into it. The Vehicle Code of 1935, an act to establish a vehicle code, thereby consolidating and revising the law relating to vehicles and vehicular traffic, and to repeal certain acts and parts of acts specified herein. The activity that is licensed by the state DMVs and in connection with which individuals must submit personal information to the DMV, the operation of motor vehicles is itself integrally related to interstate commerce, Artie. State activities integrally related to commerce and acted within its sphere of power to afford security to the rights of the people by preventing the states from releasing personal information that they require individuals to submit as a condition of engaging in an activity, which is owning and operating a motor vehicle. Owned and operated by, that's something that businesses have used forever. Owned and operated by. That's a business. That connotates a business relationship. So, owning and operating a motor vehicle that is integrally related to commerce, generally, Janet Reno, Attorney General of the United States et al., petitioners, Charlie Condon, Attorney General for the state of South Carolina et al., in the Supreme Court of the United States, January 12, 2000. So, Artie, are you going to still sit there and tell me that driving is not a commercial activity? So question number 1. Is driving an activity that is commercial in nature? Yes or no? Admit or deny? Artie, just because you've traded your rights for privileges doesn't mean that you're always a driver. You're privileged. A privileged individual has given up their rights for that privilege. So driving is not, you already, okay, this questionnaire, why don't we just say it's for you, So is driving an activity that is commercial in nature? Artie here says no. So let me refer to and I know you're not in California, Artie, but let's refer to the California Commercial Code, Section 9109. Prove it, Artie. You can talk words all you want, but you don't have anything to back it up. Back it up. You'd have no problem backing it up. I'm about to back it up right now. California Commercial Code, Section 9109, classification of goods, consumer goods, equipment, farm products, and inventory. Yeah, why not the California Vehicle Code? Goods are 1, consumer goods, if they're used or brought for use primarily for personal, family, or household purposes. 2, equipment, if they are used or bought for the use. Artie, we're going to get there. We're going to get there. Don't worry. If they're used or bought for the use primarily in business. Business equals equipment. Dude, I'm not going to go on your agenda. Sorry, buddy. We're going to go at my speed and my information here, and you're not going to run the show. And I'm going to prove you wrong, So we'll get to it, Artie. So, 1, there's 2 different kinds of goods. There is consumer goods, and that's if they're used or bought primarily for personal, family, or household purposes. 2, equipment, if they're used or bought for the use primarily in business, including farming or a profession, or by a debtor who is a nonprofit organization or a government subdivision or agency, or if the goods are not included in the definitions of inventory, farm products, or consumer goods. And that is by John A. Bone and Charles J. Williams, California law. Yeah, Artie's a total red coat. 1, the classification of goods in this section is new statutory law. The significance of this classification is described in official comment 1. Oh, if you guys want to follow along, this is the most recent article on my website, freedomfromgovernment.org. You guys can follow along with this. So I did that for you. Although goods cannot belong to more than one category at a time, they may change their classification depending on who holds them for what and for what reason. Each classification is mutually exclusive, but the 4 classifications described are intended to include all goods. So classification is determined by use, in short. The term automobile is the generic name which has been adopted by popular approval for all forms of self-propelled vehicles for use upon the highways and streets for general freight and passenger service. It's volume 1 and 2, Huddy's Encyclopedia of Automobile Law, 1932, page 140. Title 18, United States Code, Section 31, Part 1, Crimes, Chapter 2, Aircraft and Motor Vehicles, Section 31, Definitions. When used in this chapter, the term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways in the transportation of cargoes, of passengers of property or cargo. California Vehicle Code, Artie, here we go. California Vehicle Code, Section 15210I4. In the absence of a federal definition, existing definitions under this code shall apply. Section 465.4, classification as pleasure cars or commercial vehicles. A classification of motor vehicles based on whether they are used for business or commercial purposes or merely kept for pleasure or family use, a license being imposed in one case and not the other is the proper one. And that has Gulf States Utilities versus Triangle, Ohio Fisher Brothers Company versus Brown, Kelleher versus City of Portland, Tennessee, Ogilvie versus Haley, State versus Kaplan. Thus, a county ordinance levying a tax for the privilege of using the county roads and fixing no license tax on an automobile used by the owner or his family for other than commercial purposes is not unreasonable and arbitrary in the imposition of the tax on vehicles used for commercial purposes. That's Hill versus Moody. Blashfield, Automobile Law and Practice, 3rd edition, 1998, classification of motor vehicles. Okay, so that right there answers the first question. Driving is an activity that is commercial in nature, based on their own rules. Yeah, well, we're not driving. We don't drive. Driving's a privilege. Driving's a privilege that we've traded to get our right in for, to get the privilege to drive. Dude, you're missing the point. God didn't make us born with licenses. You hear what I'm saying? You did not. You can define things any way you like, but a driver is not what I am. So when you define driver, that's not me. Does that make sense? Let's move on. Question 2. Is the term, Artie, is the term motor vehicle a term used to describe a device or thing used in commercial activity? Is a motor vehicle a term used to describe a device or thing used in commercial activity? No? You say no? Okay. Bouvier's Law Dictionary, 1856. Driver. 1, employed. Bouvier's Law Dictionary, 1914, page 940. Driver. 1, employed in conducting a coach, carriage, wagon, or other vehicle. Black's Law Dictionary, 4th edition, 1951. Driver. 1, employed. Corpus Juris Secundum, section 151. Chauffeur or operator. A distinction is recognized between an operator and a chauffeur under some licensing regulations. Chauffeur referring to one who is paid for driving an automobile. You don't care about law dictionaries when you're wrong. Let's continue. 60, CJS, Motor Vehicles, section 150, or pages 150 and 151, or section 150, 151, pages 797. The California Appellate Court in 1948 defined what types of licensing is required to operate a motor vehicle. Section 250. A. It is a misdemeanor for any person to drive a motor vehicle upon a highway unless he then holds a valid operator or chauffeur's license, driving privileges of which the license is but evidence. I'm not trying to get no privilege. I don't want to be privileged. And you should have watched the live stream last night, Artie, because we talked about privileges. So, it was yesterday during the day. Sorry. The foregoing court citation clearly shows that the operator's license permits engagement in commercial activity. So, Section 1, B, the word operator shall include all persons, firms, associations, and corporations who operate motor vehicles upon any public highway in this state and thereby engage in the transportation of persons or property for hire or compensation. Yeah, Artie, bye. Go defend more pigs or something. Go defend some cops because your stuff isn't going to fly here, okay? And you're not going to be able to argue your way out of it, even though you are an attorney and you want to defend you didn't prove nothing. You didn't prove anything. And we are just getting started anyway. By the time we're done, you won't have any argument. You can't debunk. When you say debunk, that's a term that you like made up so that you can try to lie your way out of things. Yeah. Bye, Artie. We're going to have class here. We don't need you interrupting. Anyway, the word operator. The word operator shall include all persons, and let the record reflect that Artie is jumping ship instead of standing his ground. Bye, Artie. The word operator shall include all persons, firms, associations, and corporations who operate motor vehicles upon any public highway in the state and thereby engage in the transportation of persons or property for hire or compensation, but shall not include any person, firm, association, or corporation. Man overboard! Walk the plank! But shall not include any person, firm, association, or corporation who solely transports by motor vehicle persons to and from, or to and from. He just wants to get out of here because shit's going to get real. To and from attendance upon any public school, or who solely transport his or its own property or employees, or both, and who transports no persons or property for hire or compensation. Section 2. Each operator of a motor vehicle within this state who transports or desires to transport for compensation or hire persons or property upon or over any public highway within the state shall apply to and secure from the Board of Equalization of the state of California a license to operate each and all of the motor vehicles which such operator desires to operate or which such operator from time to time may operate. Yeah, you know what Artie did? He went and looked at this article on my website and he saw how in-depth it is. And he had to get the heck out of here because he's not going to be able to run his game very long. Hey, you're welcome, Alan. That's what I'm here for. Carriers, contracts. There are two kinds of carriers, namely common carriers who have been considered under another head and private carriers. These latter, the private carriers, are persons who, although they do not undertake to transport the goods of such as choose to employ them, yet agree to carry the goods of some particular person for hire from one place to another. In such case, the carrier incurs no responsibility beyond that of any other ordinary bailee for hire. That is to say, the responsibility of ordinary diligence. Gordon versus Hutchinson, it was holden that a wagoner who carries goods for hire contracts the responsibility of a common carrier, whether transportation be his principal and direct business or only an occasional and incidental employment. To bring a person within the description of a common carrier, he must exercise his business as a public employment. He must undertake to carry goods for persons generally, and he must hold himself out as ready to engage in the transportation of goods for hire as a business, not as a casual occupation pro hoc vice. And that's so the term motor vehicle is a term used to describe a device or thing used in commercial activity exclusively. Question number 3. Artie, where are you? Artie, come back. Artie, are you a driver, operator, or carrier? No, the scum pigs aren't going to just mess up your face unless you give them a reason to. If you're flying off the handle and being mean and demanding and upsetting and not polite and emotional, yeah, you'll get that. But uh, what was that? Public Enemy? What'd you say? What's up, brother? From another mother on the Public Enemy from Lighthouse Law Club, and every word you're saying is 100%, 1,000% right and very correct. I will subscribe. Hey, good looking out. Uh, so, are you a driver, operator, or carrier? Yes or no? Artie would say, "Oh, yeah, I'm one of them." But the activity licensed by state DMVs and in connection with which individuals must submit personal information to the DMV, the operation of motor vehicles is itself integrally related to interstate commerce. State activities integrally related to commerce and acted within its sphere of power to afford security to the rights of the people by preventing the states from releasing personal information that they require individuals to submit as a condition of engaging in activity owning and operating a motor vehicle that is integrally related to commerce generally. Hey, David, what's up? That's from Janet Reno, January of 2000, talking about driving being only commerce. So, I'm not that. I'm not selling my time when I'm out there. They have some mental blocks, Alan. They have some mental blocks for sure. And they're foreign agents as well. Yep. So number 4, when you use your car, are you engaged in the activity that the DMV regulates? Yes or no? To answer this, my dogs are great. They're being taken care of by someone in the chat, as a matter of fact. Yeah, I'm away from the homestead at the moment. I'm out here in Salt Lake City, downtown in a hotel, talking about freedom for a few more days. So, when you use your car, are you engaged in the activity that the DMV regulates? Yes or no? Here's the answer. Vehicle Code 1935. Section 4. Pending proceedings and accrued rights. No action or proceeding commenced before this code takes effect, and no right accrued is affected by the provisions of this code, but all procedure thereafter, taken therein shall conform to the provisions of this code so far as possible. And then in the California Vehicle Code 1988, pending and proceeding accrued rights, number 4, no action or proceeding commenced before this code takes effect, and no right accrued is affected by the provisions of this code, but all procedure thereafter taken therein shall conform to the provisions of this code so far as possible. And then the Constitution of the State of California of 1849, Section 1 says, all men are by nature free and independent and have certain unalienable rights, among which are those enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining safety and happiness. Section 10 of that same Constitution, the people shall have the right to freely assemble together. Section 21 of that same Constitution, this enumeration of rights shall not be construed to impair or deny others that are retained by the people. California Vehicle Code 17451, the acceptance by a non-resident of the rights and privileges conferred upon him by this code. 17453, the acceptance of rights and privileges under this code. So, it's very interesting that they talk about rights and privileges. They are not the same thing. So the answer to this question number 4, when you use your car, are you engaged in the activity the DMV regulates? It could be either way. It depends on capacity. Yeah, Artie supports violence. He also defends the criminals, who are the police. They gotta all stick together because they are losing bad. So that brings us to question number 5. Are the rights and privileges that we just discussed offered by the DMV, are they accrued rights? Yes or no? Artie's just this, he's an attorney, he's brainwashed, and he can't fathom that people would be able to travel by right. You know what I'm saying? So, number 5. Are the rights and privileges we just talked about offered by the DMV, are they accrued rights? Yes or no? Definitions and sources of law. 2 to 22.2 Civil Code, Section 222 to 22.2. Yes, rights and privileges don't mix. If you're privileged, you don't have rights anymore. Number 22. Law is a solemn expression of the will of the supreme power of the state. 22.1. The will of the supreme power is expressed, A, by the Constitution, and B, by statutes. 22.2. The common law of England, so far as it is not repugnant to or inconsistent with the Constitution of the United States or the Constitution or laws of this state, is the rule of decision in all the courts of the state. So, what does that tell us? I don't think they're accrued. Number 6, is the vehicle code the law? Yes or no? And come on, where's Artie, man? Why can't you stick with us? We were about to have fun and stuff. So, is vehicle code the law? Yes or no? And if so, why didn't the legislature avoid any confusion or question by authorizing Civil Code Section 22.1 to read the following way? The will of the supreme power is expressed by the Constitution, by the statutes, and by the codes. It didn't say that. There was no mention of codes. So the code is not a law. Yeah, it's not a law. Bonehead, you're right. The Constitution of the State of California, 1849, Article 3, Distribution of Powers. The powers of the government of the State of California shall be divided into 3 separate departments: the legislative, the executive, and the judicial. And no person charged with the exercise of powers properly belonging to one of these departments shall exercise any functions appertaining to either of the others, except in the cases hereinafter expressly directed or permitted. So that answers our question. Codes are not law. Yeah, this is about the difference between driving and traveling. And after this video, you will know which one you're doing. I promise. Number 7, do judges have any discretion to expand the meaning of any code section by adding words the legislature elected to leave out? Yes or no? The legislature, either by amending Section 1382 or otherwise, may not nullify a constitutional provision. In other words, the legislature cannot change things. A state cannot impose restrictions on the acceptance of a license that will deprive the licensee of his constitutional rights. That's Ruckenbrod versus Mullins in Utah, right here, where I'm at right now, Salt Lake City. Hey! I'm going to say it again. A state cannot impose restrictions on the acceptance of a license that will deprive the licensee of his constitutional rights, Artie. Okay? So, the judges that answers our question. The judges do not have any discretion to expand the meaning of any code section by adding words the legislature elected to leave out. They can't change it. That brings us to number 8. Does the legislature have the authority to enact legislation compelling the waiver of constitutionally secured rights in favor of acceptance of inferior government-granted taxable and revocable privileges? Yes or no? A license is the general nature of a special privilege, entitling the licensee to do something that he would not be entitled to do without the license. 51, American Jurisprudence 2D, Licenses and Permits, Part 1, General Principles, generally. That's what that's from. So if you can do it, if you have a special privilege to do something with a license, you're able to do something that you wouldn't ordinarily be able to do without the license, which is operate in commercial capacity. So the legislature does not have the authority to enact legislation compelling the waiver of constitutionally secured rights in favor of acceptance of inferior government granted taxable and revocable privileges. Number 9. Are the unalienable rights and immunities secured by the Constitution, are they special privileges? Because we just saw that when it referred to privilege, it was granting the special privilege, So what is the general nature of a special privilege? I don't think that the unalienable rights and immunities secured by the Constitution are special privileges. No, they're unalienable, which means they can't be taken away. And you can't even give them away, okay? Number 10, predicated on the foregoing authorities, are you engaged in the activity the DMV regulates? I'm thinking no. Number 11, does the legislature possess the authority to compel you to apply for and pay for an annual fee for a license when you don't do what the license permits? No, I don't think so. Number 12, does the legislature possess the authority to compel you to transfer an interest in your private property to any agency of state government? They sure shit don't. Terms found in the California... Yeah, we will. I'm going to do it. I'm going to do it. I'm going to be streaming live. And if you guys go right now and sub to my other channel called Partially Woke, I'm almost to 1,000 subs on there. I'll have 2 live streams going at once next time. Yeah, Artie is. He is. I determined that a while ago. But he does give me traffic, so it's a trade-off. Haters going to hate, but I'll take the exposure, right? Terms found in the California Vehicle Code and associated with the DMV and applied to those persons who do what the DMV regulates, commercial, relating to or connected with trade and traffic or commerce in general. Zante Currents, occupied with commerce, Bowles versus cooperative. Black's Law Dictionary, 4th edition, page 337. Interstate commerce, traffic, intercourse, commercial trading of the transportation of persons or property between or among the several states of the Union. From between points in one state and points in another state, commerce between the states or between places in different states. It comprehends all of the component parts of commercial intercourse between different states. That's Black's Law Dictionary, 4th edition, page 955. Yeah, everybody. Right now, we're doing a special. I'm gonna try to get them out here. Right now, we're doing a special. Every order, or 1 in 10 orders on the website shop.freedomfromgovernment.org, receives one of these ounces of silver in the form of a silver eagle from the year 2020, because this way you can say that you actually got something good out of it. Yes. Ooh. We got silver. We're giving away silver in a silver squeeze market. That's right. Silver. 1 in 10 orders gets a free ounce. So if you buy Like, let's see. If you get 10 of these cards for $5 from the website, you have a chance to get a $50 value coin included with your card when it comes in the mail. So keep that in mind. Shop.freedomfromgovernment.org. And I'm only running this special through tomorrow, as far as I know. I might extend it tomorrow for another week. But, someone said, how about correcting one's status? My status is that of a child of God. God never took that status away from me. And that's the most powerful status in the world. So I'm going to use that status. That's how I correct my status, is I deny the earthly ones and go back to my God-given one, Anyway, transportation. The removal of goods or persons from one place to another by a carrier. That's Black's Law Dictionary, 4th edition, page 1670. Bailee, contracts, one to whom goods are bailed. His duties are to act in good faith. He is bound to use extraordinary diligence in those contracts or bailments where he alone receives the benefit. As in loans, he must observe every diligence of those bailments, which are beneficial to both parties. As hiring, and he will be responsible for gross negligence in those bailments which are only for the benefit of the bailor, is deposit and mandate. He is bound to return the property as soon as the purpose for which it was bailed shall have been accomplished. 3, he generally has a right to retain and use the thing bailed according to the contract until the object of the bailment shall have been accomplished. 4, a bailee with a mere naked authority having a right to remuneration for his trouble, but coupled with other interests, may support trespass for any injury amounting to a trespass done while he was in actual possession of the thing. Are you aware of what that, if they're going to claim that your property is bailed, they have to allow you to do what you need to do with it, without trespassing against you. Hey, everybody, we got 100 people watching right now. Please, if you enjoy this content, please take a second to smash that like button. We need to get exposed to more people. Yes, right on. Thank you, guys. The number plates and or emblems are the evidence that the license has been acquired. So if you're running tags, that's prima facie evidence that the license has been acquired, and they are therefore allowed to do what they do, That's why you have to take those numbers off. That's why I don't have that on there. That's why we have the tags that say DOT exempt and peace on earth, because God didn't require driver's license or license plates or insurance. God gave us free will for a reason. And, that's so that we can learn responsibility. We need to be responsible for ourselves. So the License Tax Act of 1933 was enacted as a step in the second line that of certain acts and constitutional provisions which were primarily revenue measures designed to secure the state a fair return for the use of the public highway of the state in transporting persons or property for compensation. These enactments have been before the courts of the state in the following cases. Yes, that's what I'm trying to do here, Rad. Bacon Service Corp versus Huss. Los Angeles, etc. Transportation Company versus Superior Court. People versus Duntley. Allward versus Johnson. People versus Lang Transportation Company. See, these are transportation companies, An analysis of the legislative history discloses the fact that all the statutes dealing with the regulation of transportation agencies refer to persons in the business of transportation of persons or property upon the public highways for hire compensation. Rad. I said it again. We are satisfied that the purpose of the enactment of the License Tax Act of 1933 was to secure a fair return to the state for the use of its public highways, not only from carriers, both common carriers and private contract carriers, but also from the larger class of persons who fairly answer to the description of operator, therein defined as taxable, and who receive compensation, either directly or indirectly, from use of the public highways. If you're not getting paid, you don't have to sign up. That's what I'm saying. And they're wrong when they try to make you, when they try to enforce their color of law, wrongness, So California Commercial Code, former section 9109, classification of goods, consumer goods, equipment, farm products, inventory. Goods are: 1, consumer goods if they are used or bought primarily for personal, family, or household purposes. That's your car. Or 2, equipment if they are used or bought for the use primarily in business, including farming or a profession, or by a debtor who is a nonprofit organization or a government subdivision or agency, or if the goods are not included in the definitions of inventory, farm products, or consumer goods. Hey, Gizmo, you know what? I can sit here and say that they don't care about me, they don't care about anything, but I'm not out there. When I say that, I'm like presuming something because I'm not out there actually being involved with people. I'm just like shooting myself in the foot before I even start. So positive mental attitude is like, that is one of the biggest parts of even starting to go down this path. And when you negate your manifestation and your reality by speaking into existence words that keep you oppressed, we can't. There's no doubt that it's going to work like it's intended. So your word is your law. When you speak, be real careful that your words are appropriate. Or something that you would be okay manifesting. So. California Code comment by John A. Bone and Charles J. Williams, prior California law. Number 1, the classification of goods in this section is new statutory law. The significance of this classification is described in official comment 1. Although goods cannot belong to more than one category at any time, they may change their classification depending on who holds them and for what reason. Each classification is mutually exclusive, but the 4 classifications described are intended to include all goods. So do you use your car in the way equipment is defined, or do you use your car as consumer goods, the way consumer goods is defined? The license permits activity that would be illegal without the license. Licenses authorizes the exercise of a privileged activity. The privilege to be exercised is inferior to the unalienable or fundamental rights secured by both state and federal constitutions. Moreover, a distinction must be observed between the regulation of an activity which may be engaged in as a matter of right and one carried on by a government sufferance or permission. Packard versus Banton. Its object is to confer right or power which does not exist without it, and exercise of which without license would be illegal. That's Intercity Coach Lines versus Harrison. A permit granted by an appropriate governmental body, generally for consideration to a person, firm, or a corporation, to pursue some occupation or to carry on some business which is subject to regulation under the police power. Rosenblatt versus California State Board of Pharmacy. The term license implies a divestiture of right or title by the licensee to the property which is subject to the license. A license is merely a revocable privilege to do an act or series of acts upon land and executes the right or title thereto. Eastman versus Piper, Gravely Ford Canal Company versus Pope and Talbot Land Company, Howes versus Barman. A license is no more than a temporary permit to do that which would otherwise be unlawful. Travel is not unlawful. Rawson versus licenses. The only limitations found restricting the right of the state to condition the use of the public highways as a means of vehicular transportation for compensation are: one, that the state must not exact of those it permits to use the highways for hauling for gain, that they shall surrender any of their inherent U.S. constitutional rights as a condition precedent to obtaining permission for such use. Riley versus Lawson, Stevenson versus Binford, which is a privilege to engage vehicle, automobile, license, driver, operator, passenger, driving privilege. If you do not engage the commercial activity that the word driving represents, you can be required to apply for a driver's license and declare that you engage in commercial activity. If you're not a general contractor, can you be forced to get a license permitting general contracting? If you're not an attorney, Artie, can you be forced to get a license to practice law? If you do not hunt or fish, can you be forced to get a hunting or fishing license? Is it possible that you misclassified your car? Did you use the proper definition to describe your car? The word car merely describes an amalgam of different components. The words motor vehicle also describes an amalgam of different components. There is a distinction in use. The amalgam of different components the words car and motor vehicle describe. This is reasonably deducted from the foregoing court citations and codes. One term is a designation of the amalgamated components being for commercial use or application. The other term is a colloquial definition of amalgamated components used to merely travel from point A to point B for private personal reasons of a non-commercial nature. It can be reasonably argued the terms covered wagon and car mean the same thing, a device used to go from point A to point B. And it could be further argued that, like the covered wagon, the private car is not an item the legislature has any authority to compel the owner to register unless it was for purposes which the legislature had legitimate authority to regulate under the police powers of state government. What do you have to say about that, Artie? Does the legislature have authority to compel the people to convey an interest in their private property to any government institution? I'd say no. Government is instituted for the protection, security, and benefit of the people. Article 1, Section 2 of the Constitution of the State of California, 1849. If the legislature does not have absolute authority to compel the owner of a car to register it, then there must necessarily be conditions and the terms used and published somewhere so that one can come to an accurate determination that the registration requirements apply to their property which they use to travel from point A to point B. The following Attorney General opinion will shed light on the issue of your car as bail and who the bailer be and the relationship thereof. To be published in the official reports, Office of the Attorney General, State of California, Daniel E. Lundgren, Attorney General. Opinion, number 97-202 of June 9, 1997. Daniel E. Lundgren, Attorney General. Clayton P. Roach, Deputy Attorney General. The Honorable Dick Monteith, member of the California State Senate, has requested an opinion on the following question. When the owner of a vehicle has been arrested for driving without a valid license and the vehicle has been impounded, may the owner be found guilty of grand theft for removing the vehicle from the impounding agency's custody without permission or authority prior to the expiration of the 30-day impoundment period. Conclusion. When the owner of a vehicle has been arrested for driving without a valid license and the vehicle has been impounded, the owner may be found guilty of grand theft for removing the vehicle from the impounding agency's custody without permission or authority prior to the expiration of the 30-day impoundment period. Analysis. Vehicle Code Section 14602.6, footnote number 1 provides A, whenever a peace officer determines that the person was driving a vehicle while his or her driving privilege was suspended or revoked without ever having been issued a license, the peace officer may either immediately arrest the person and cause the removal and seizure of that vehicle if the vehicle is involved in a traffic collision, or cause the removal and seizure of the vehicle without the necessity of arresting the person A vehicle so impounded shall be impounded for 30 days. The impounding agency, within 2 working days of impoundment, shall send a notice by certified mail, return receipt requested, to the owner of the vehicle at the address obtained from the department, informing the owner that the vehicle has been impounded. Failure to notify the legal owner within 2 working days shall prohibit the impounding agency from charging for more than 15 days impoundment when the legal owner redeems the impounded vehicle. B. The registered and legal owner of a vehicle that is removed and seized under Subdivision A or their agent shall be provided the opportunity for a storage hearing to determine the validity of or consider any mitigating circumstances attendant to the storage. We are asked whether the owner of a vehicle that has been impounded pursuant to Section 14602.6 may be found guilty of grand theft if he or she removes the vehicle without permission or authority from the custody of the impounding agency before the expiration of the impoundment period. We conclude that a person may be found guilty of grand theft in such circumstances. Penal Code 487, Section 487, defines grand theft as follows. Grand theft is theft committed in any of the following cases. D. When the property taken is an automobile or firearm. Penal Code Section 489 describes the punishment for grand theft. Grand theft is punishable as follows. When the grand theft involves theft of a firearm by imprisonment of the state in the state prison for 16 months, 2 or 3 years. B. In all other cases, by imprisonment in a county jail not exceeding 1 year or in the state prison. The key statute requiring our analysis is Penal Code Section 484, which defines theft as follows. Every person who shall feloniously steal, take, carry, lead, or drive away the personal property of another, who shall fraudulently appropriate property which has been entrusted to him, or who shall knowingly and designatedly, by any false or fraudulent representation or fraud, any other person of money, labor, or real estate, real or personal property, or who causes or procures others to report falsely of his wealth or mercantile character, and by thus imposing upon any person obtains credit and thereby fraudulently gets or obtains possession of money or property or obtains the labor or service of another, is guilty of theft. In the circumstances presented for consideration, the owner of a vehicle has removed the vehicle from an impounding agency's custody without permission or authority prior to the expiration of statutory impoundment period. The owner has not contested the seizure or impoundment of the vehicle through the storage hearing procedure established by the legislature. Rather, the owner has taken the vehicle at a time when he or she has no right to possession. While the taking of a vehicle may ordinarily be considered grand theft, Penal Code 487, Section 487, subsection D, the vehicle is in these circumstances the personal property of another, so as to constitute theft. In other words, may a person be found guilty of stealing his or her own automobile? The answer to that question has been settled in California for well over 100 years. In the early case of People v. Stone, 1860, the possession of certain personal property was given by the owner to his creditor until the debt was paid. This court ruled that the owner could be found guilty of larceny, feloniously go away with the personal property of another, if he took back the property without the consent of the creditor prior to the time the debt was paid. The Supreme Court ruled similarly that the cases of People v. Thompson, 1868, if a man takes his own goods from the possession of his bailee without his knowledge and consent, the taking may be larceny. And Jones v. Jones, a man may steal his own property. And in People v. Kane, 1907, the court declared the phrase personal property of another is used in Section 484 of the Penal Code, correctly interpreted, which means the property in the possession of another who is entitled as bailee, or otherwise to retain possession thereof for some benefit or profit to himself to the exclusion of all others. Hey, High Impact Flicks! Good to see you. Good to see you, man. Our conclusion is that the taking of property by the general owner thereof from the possession of one who rightfully holds it as bailee or otherwise to benefit himself, with the intent to charge such bailee with the value thereof, or deprive him of such benefit, constitutes larceny. I don't know. They stole my partnership, and I'm not monetized. I don't know. I am giving away silver. I'm giving away silver. Silver Eagles. 1 in 10 orders on my website. 1 in 10 orders on my website gets a random Silver Eagle sent to them, and these are year 2020, so we can say that we did get something good from that year after the fact. I got a bunch of them. 1 in 10 wins. All day long. All night long. In People versus Photo, 1941, the court reaffirmed that the phrase personal property of another may refer to someone who has rightful custody of the property, but not absolute ownership. The allegation in the information appellants took the personal property of another, as that term is used in Section 484 of the Penal Code, means property in the possession of another who is entitled as bailee, lien claimant, or otherwise to retain possession thereof for some benefit or profit to himself to the exclusion of all others, rather than the absolute ownership defined in Section 679 of the Penal Code, of the Civil Code, sorry. Here we are given that the owner of the vehicle has no right of possession at the time of the taking of the vehicle from custody of the impounding agency. We believe that the foregoing cases support the conclusion that one may be prosecuted from another's lawful possession. A charge of grand theft may thus be proved under the limited facts we have been given. People versus Stone. We realize the taking of a vehicle from the lawful possession of another may constitute different crimes depending on the circumstances, especially upon the intent of the person taking the vehicle. Also, a settled rule of statutory construction precludes prosecution under a general statute when more specific one describes the conduct involved. However, we do not have facts establishing an offense under any other criminal statute. People versus Curtin. Discussion of crimes of larceny by trade device and obtaining property by false pretenses. Accordingly, the general statute making grand theft a crime would be applicable here. We thus conclude that when the owner of a vehicle has been arrested for driving without a valid license and the vehicle has been impounded, the owner may be found guilty of grand theft for removing the vehicle from the impounding agency's custody without permission or authority prior to the 30-day impoundment period. Footnote 1. All references hereafter to the vehicle code are by section number only. The ownership of property is absolute when a single person has the absolute dominion over it and may use it or dispose of it according to his pleasure, subject only to general laws, but not if it is bailed, not if it's not owned by you, or if it's leased, or if you're making payments, it's not yours yet. If inconsistencies exist in the punishment for similar offenses under different statutes, it is for the legislature to consider and address. Finn versus Superior Court. Footnote number 4. In Rejoiner Supra, the court found that the grand theft statute was inapplicable on facts somewhat similar to those present here. Since a specific statute covered the actions of the defendant, the legislature has changed the statutory language examined in Joiner, and it would no longer cover the limited circumstances we have been given. Hence, sections 484 and 487 remain applicable in our situation. Can one of the sovereign people be compelled to divest themselves of absolute dominion of their unalienable rights and immunities by municipal government employee without a court order? Can one of the sovereign people be compelled to waive their unalienable rights and immunities suffering under the auspices of metis? Can one be compelled to divulge information that may be used to incriminate themselves as a condition of due process of law? What do they do when they pull you over? The first thing they do is like, hey, how about testifying against yourself here today? We really would appreciate it so we can generate some more revenue. Once the accused exercises their right to remain silent and notifies the arresting officer of the exercise of secured rights at Section 8 of the Constitution of the State of California, 1849, can the arresting officer compel an admission or confession? We begin with the fundamental premise that the objective of statutory interpretation is to ascertain and effectuate legal legislative intent. In determining the legislature's intent, we are to look first to the language of the statute, giving effect to its plain meaning. Kimmel versus Golan, 1990. The words of the statute. Hold on. Good coffee. It's from Raw Bean here in Salt Lake. In determining the legislature's intent, we are to look first at the language of the statute, giving effect to its plain meaning. The words of the statute must be construed in context, keeping in mind the statutory purpose, and statutes or statutory sections relating to the same subject must be harmonized, both internally and with each other, to the extent possible. Dynamed Inc. versus Fair Employment and Housing Commission, 1987. Reports of legislative committees and commissioners are part of the statute's legislative history and may be considered when the meaning of a statute is unclear. Huntnick versus U.S. Fidelity and Garrity Company. The well-established principle that the courts must give statutes a reasonable construction which conforms to the apparent purpose and intention of the lawmakers. Clean Air Constituency versus California Air Resources. To be published in the official reports, Office of the Attorney General, State of California, Daniel Lundgren, Attorney General, Vehicle Code, 1935, Section 81. Street or highway is a place or is a way or place of whatever nature open to the use of public as a matter of right for purposes of vehicular travel. So if driving is a privilege, how come they are referring to a street or highway being open to the use of the public as a matter of right? For purposes of vehicular travel. They didn't even say driving. So the highway is to remain open to the use of the public as a matter of right, not of a matter of privilege. As a matter of right, not sufferance, which government permission. The exercise of constitutionally secured inalienable rights does not require the party wishing to exercise such rights to ask for government permission, which permission is evidenced by the driver license. The driver license is merely evidence you asked for and are in possession of something belonging to the state and consented to be regulated by the terms and conditions found within the Vehicle Code. Even as late as 1950, the California Supreme Court said, fundamentally, it must be recognized that in this country, highways are for the use of the traveling public, and all have the right to use them in a reasonable and proper manner, and subject to proper regulations as to the manner of use. That means, like, don't be reckless. Don't go out being crazy, you know? The streets of a city belong to the people of the state, and the use thereof is an inalienable right of every citizen. Yeah, I'm not here to testify, especially not against myself. The streets of a city belong to the people of the state, and the use thereof is an inalienable right of every citizen, subject to legislative control or such reasonable regulations as to the traffic thereon, or the manner of using them as the legislature may deem wise or proper to adapt and impose. But they only have regulatory powers over commerce, according to the Commerce Clause of the Federal Constitution. Streets and highways are established and maintained primarily for purposes of travel and transportation by the public. So travel and transportation are they're different things. And use is incidental there too. Such travel may be for either business or pleasure. The use of highways for purposes of travel and transportation is not a mere privilege, but a common and fundamental right of which the public and individuals cannot rightfully be deprived. All persons have an equal right to use them for purposes of travel by proper means and with regard for the corresponding rights of others. It's American Jurisprudence, page 456, 457. Also see Corpus Juris Secundum 244, 247, Section 233, and Escobedo versus State of California, 1950. Yeah, that's right. That's what's up. If you do not engage in commercial activity that the word driving represents, can you be required to apply for a driver's license and declare that you do engage in commercial activity, which is represented by the term driving? When you signed your name on the application for privileges at the DMV, you did so under penalty of perjury that the foregoing information you placed on the application and other documents was true and correct. Predicated on the foregoing, have you committed perjury? Predicated on the foregoing, have you declared to be true that which is not true? A contract may be rescinded by the act of a party entitled and desiring to rescind. McNeese versus McNeese, 1923, California. A contract obtained under any element of fraud, such as non-disclosure, misrepresentation, withholding of pertinent facts, can be rescinded by serving a notice of rescission. Prewitt versus Sunnymead Orchard Company. Yeah, we're stopping the lies and we're bringing back truth. A writing is void ab initio, or from the beginning, in the case of fraud in the inception, and it need not be formally rescinded as a prerequisite to right of avoidance. This is why I tell everybody to cry fraud, because it is void from the beginning if you say that it is fraud, that you don't wish to act in fraud anymore. I know it's tough, but if you don't stand up for yourself and call it like it is, they're going to run you through the ringer, and they do it every day. So we have to know what we're doing, and we have to speak up. We have to stand on our rights, and we don't want to admit to having any kind of privileges from them. That last writing is void ab initio in the case of fraud of Indians, and it need not be formally rescinded as a prerequisite to right of avoidance. That's Bonacci versus Massachusetts Bonding Insurance Company. And then Civil Code section 1619 to 1633 says, 1619, a contract is either express or implied. 1620, an express contract is one, the terms of which are stated in words. 1621, an implied contract is one, in terms of which are manifested by conduct. 1622, all contracts may be oral, except such as are specially required by statute to be in writing. Vehicle Code 7453, the acceptance of rights and privileges under this code or any operation of a motor vehicle anywhere within this state as specified in section 17451 shall be a signification of the irrevocable of the non-resident binding as well as his executor or administrator. That process against him, which is served in the manner provided in this article, shall be of the same legal force and validity as if served on him personally in this state. Emphasis added. Civil Code section 1688 to 1693. 1688. A contract is extinguished by its rescission. Thereto consent. B. A party to a contract is in cases. 1. If the consent of the party rescinding or of any party jointly contracting with him was given by mistake or obtained through duress, menace, fraud, or undue influence, exercised by or with the connivance of the party as to whom he rescinds, or of any other party to the contract jointly interested with such party. 2. If the consideration for the obligation of the rescinding party fails in whole or in part through the fault of the party as to whom he rescinds. 3. If the consideration for the obligation of the rescinding party becomes entirely void from any cause. 4. I like that. I like the comments because we're getting it from two different ways and stuff. It's pretty awesome. 4. If the consideration for the obligation of the rescinding party before it is rendered to him fails in a material respect from any cause. 5. If the contract is unlawful for causes which do not appear in its terms or conditions. and the parties are not equally at fault. 6, if the public interest will be prejudiced by permitting the contract to stand. Number 7, under the circumstances provided for in Section 39, 1533, 1566, 1785, 1789, and 2314 of this code, Section 2470 of the Corporations Code, Section 331, Section 338, 359, 447, 1904, and 2030 of the Insurance Code, or any other statute providing for rescission. So if you have determined that you are erred by declaring true that which isn't true, you have an obligation to notify the other party to the contract so that steps can be taken to correct the fraud. There's no statute of limitations on fraud, and an agreement does not become valid over the course of time when there are elements of fraud found in the inception of the agreement. It can be easily demonstrated that the fraud existed at the time of the contracting parties first met. 1, the party wanting the benefits or privileges offered by the DMV was unaware that the DMV participated in the regulation of interstate commerce. 2, the party wanting benefits or privileges from the DMV was unaware that the term driver represented one engaged in government-regulated commercial traffic activity. 3, the party wanting benefits, privileges from the DMV was unaware that the term motor vehicle described a device used for commercial purposes. 4, the party wanting benefits or privileges from the DMV was unaware that the license issued by the DMV authorizes engagement in a privileged government-regulated commercial activity. 5, the party wanting benefits and privileges from the DMV. Yeah, Artie's gone. Like, he can't even hang. He can't hang. The party wanting benefits and privileges from the DMV was unaware that in order to receive such benefits and privileges, they would have to waive their constitutionally secured inalienable rights. Unalienable rights. See, that's all we got to do is say we don't wish to participate in fraud anymore. The party wanting benefits and number 6, the party wanting benefits and privileges from the DMV was unaware that in order to get the benefits and privileges offered by the DMV, they must first alter their primary citizenship acquired at birth to that of a second-class citizen without access to their fundamental rights. Number 7, the party wanting benefits and privileges from the DMV must enter a federal government welfare program, Social Security. Number 8, the party wanting and privileges from the DMV was unaware that they were about to enter an irrevocable agreement. Number 9, the party wanting benefits and privileges from the DMV thought they were required to get a license before they could lawfully use their property on the streets and highways that they pay for in legitimate taxes. Number 10, the party wanting benefits and privileges from the DMV was unaware they could not be compelled to transfer an interest in their private property to the DMV. And with that, that concludes today's lesson. And wow, we had a good thing going on today. Quite a few viewers. I hope everybody wants to learn about this stuff. And I'm going to say it one more time. You go to this freedomfromgovernment.org. Is that backwards? Crap. If you go to freedomfromgovernment.org, any order placed at that website through tomorrow, and possibly even through next week, but I'm not sure yet, through tomorrow, 1 in 10 chance of getting a Silver Eagle 0.999 fine, 1 ounce coin. So, yeah, hey, thank you guys. I love you all, and I love doing these, and we're not stopping. And attorneys are even going to learn something, So there's that. All right. Hey, thanks again. Thanks so much for being here. And smash the like button. And don't forget to sub to Partially Woke. Hey, thanks, Bonehead, for throwing that link in there. Yeah, because we want 2 streams instead of 1. 2 is better than 1, right? All right. Hey, thanks. And of course, like always, peace.